There's a billionaire, and if you don't know his name, you certainly know his business background. Les Wexner will be grilled tomorrow. This is part of what has become a bipartisan rebuke to Donald Trump over and over on the Epstein files. He said no new files. Congress made him release them. That's the story we've been following. He said, let it go. It's an old story. Congress said, no, there's more to do. And so it stays in the news because of these actual investigative developments. Now, Wexner had a long and very big kind of business relationship with Epstein. The question is, what kind of business? But tens of millions of dollars were exchanged. This deposition will occur in Ohio. That's part of an accommodation of the witness, who is 88 years old. Now, when I mentioned business, what these two men did in business is part of what's under investigation. So on the one hand, we could tell you that Wexner was a successful businessman, a billionaire, and that he was also a benefactor of Epstein, that he helped him financially.
14 minutes. That's how long the sitting president of the United States is heard on a secretly recorded call, calmly instructing a witness to lie, not speculate, not imply, instruct. The recording, filed in federal court, captures Donald Trump telling a potential witness to deny conversations that prosecutors say unquestionably occurred. He tells the witness to claim memory loss. He scripts alternative facts. He insists the discussion remains secret. And then he says the quiet part out loud, don't tell your lawyer.
Maybe that's all there was to it. We want to be careful and follow the facts. But lawmakers, investigators, and independent journalists have raised the question of just why so much of Wexner's money ended up in Epstein's pockets. At one point, Epstein was managing Wexner's finances. Then they did sever ties. And that was in 2007 as more heat came on Epstein. What we're learning from the files, though, is that Wexner is in there over 1,000 times. Emails, lawsuits that seem to involve potentially both of them. And the DOJ has even modified some of the redactions to the 2019 FBI file that showed...
Pause there. A president advising someone to hide information from their own counsel is not a misunderstanding. It is not political spin. It is not locker room exaggeration. It is consciousness of guilt captured in real time. And this wasn't recorded by an adversary in some hostile newsroom. It was recorded by a witness who, according to court filings, decided the safest course of action was to preserve the evidence. Ask yourself why someone close enough to have that conversation felt the need to document it. The date matters. December 18th, 2023. At that moment, Trump was already under federal investigation for obstruction and unlawful retention of classified documents. He knew the special counsel was circling. He knew subpoenas had been issued. And still, according to the filing, he doubled down. That's not a lapse in judgment. That's escalation under pressure. On the tape, he allegedly tells the witness, "You need to say you don't remember." That phrase sounds almost casual. It isn't. Under 18 U.S.C. prior 1512, attempting to influence testimony with intent to affect an official proceeding is a felony. The statute does not carve out exemptions for former presidents. It does not bend for political inconvenience. It criminalizes precisely what this recording appears to capture, an effort to shape testimony before it ever reaches a courtroom. And then it gets worse. He reportedly says, if they ask about the Pence conversation, you say we never discussed that. That is not coaching. That is scripting denial of a specific exchange tied to January 6th. It narrows the target. It identifies the subject. It instructs the falsehood. When a defendant dictates which facts must disappear, prosecutors call that intent. But intent alone isn't the story. Secrecy is. This is between us. That line, prosecutors argue, demonstrates awareness that the conversation itself is improper. Lawful advice doesn't require isolation. Truth doesn't demand concealment. And when he adds, "Don't tell your lawyer," the implication becomes seismic. Lawyers exist to protect clients from legal exposure. Telling a witness to withhold information from counsel suggests the speaker understands the exposure is real. That is the anatomy of obstruction. Now consider the broader context. The recording was made while Trump was at Mar-a-Lago. The witness was reportedly in Virginia. The call crosses state lines. It references file boxes and classified material. That means this is not just about election interference narratives. It bleeds directly into the classified documents case. If the tape reflects discussion of sensitive materials, while simultaneously instructing false testimony about them, prosecutors may argue it demonstrates knowledge and concealment in one continuous act. Knowledge plus concealment equals jeopardy. The filing invoking the crime fraud exception is another warning sign. Attorney-client privilege is not a shield for criminal conduct. If a communication is in furtherance of a crime, courts can pierce the privilege. By placing this tape before a federal judge under that doctrine, prosecutors are effectively arguing that the conversation itself was part of an ongoing effort to obstruct justice. That is not procedural housekeeping. That is a declaration of gravity. And here's the destabilizing implication. Prosecutors have reportedly possessed this recording for some time. They didn't leak it. They didn't weaponize it for headlines. They filed it when procedurally required. That suggests discipline. It suggests confidence. It suggests they believe the evidence can withstand forensic scrutiny, cross-examination, and jury evaluation. Trump's public response? He calls it fake, fabricated, another deep state attack. That defense might resonate in a rally. It collapses in a courtroom. Audio authentication is a science. Voice identification, waveform analysis, metadata verification, these are not partisan tools. If experts have validated the recording, denial becomes performance, not rebuttal, and juries are not Twitter feeds. Imagine this played in open court. A silent room, 12 citizens, the president's own voice instructing a witness to deny reality. There is no need for interpretive gymnastics. The words stand alone. You can argue motive. You can argue politics. You cannot argue with the sound of your own directives. That is why this is different. Obstruction cases often hinge on inference, emails, deleted messages, coded language. Here, prosecutors appear to have direct language, direct instruction, direct secrecy, direct attempt to shape testimony. In legal terms, that is evidentiary gold. In constitutional terms, it is wrought at the core of executive responsibility, because the presidency is not merely an office, it is a constitutional trust. The separation of powers assumes good faith execution of the law. When a president allegedly interferes with a federal investigation into his own conduct, the issue is no longer partisan. It becomes structural. It asks whether the executive branch can be trusted to respect judicial authority. If the answer is no, the damage extends beyond one man. There is also the psychological pattern. When cornered, Trump does not retreat. He pressures, he reframes, he demands loyalty. That pattern has surfaced before. Requests for perfect calls, public attacks on witnesses, social media intimidation. This recording, if accurate, fits that pattern with forensic clarity. It is not an outlier. It is a continuation. And continuations matter in court. They establish habit. They establish method. They establish that an act was not accidental, but consistent with prior conduct. Politically, the timing intersects with national elections. That will inflame rhetoric. Allies will claim interference. Opponents will claim accountability. But the calendar does not nullify evidence. Federal proceedings move according to rules, not campaign schedules. If anything, the proximity to elections raises the stakes for the rule of law. Do institutions enforce statutes even when the defendant commands a political movement? That question is now unavoidable. If additional charges emerge under Paragraph 1512, potential penalties could reach decades. Sentencing is complex, contingent on conviction and judicial discretion. But the theoretical exposure alone alters the landscape. A candidate facing authenticated audio of alleged witness tampering does not operate from a position of legal strength. He operates under cloud, and clouds accumulate. There is another layer. By allegedly instructing a witness not to involve counsel, Trump may have undermined the very defenses his attorneys could later assert. Defense strategies rely on transparency between client and lawyer. If a defendant is privately orchestrating false testimony, it constrains plausible explanations. It narrows maneuvering space. It creates internal contradictions that skilled prosecutors exploit. That is how cases implode from within. Supporters will argue that conversations are taken out of context. That tone matters. That intent is misread. Context will indeed be litigated, but context does not erase explicit directives. Say you don't remember is not ambiguous. We never discuss that is not philosophical. Don't tell your lawyer is not administrative. Each phrase carries weight. Together, they form a chain. The constitutional crisis is not theatrical. It is procedural. It asks whether a president can leverage personal influence to distort testimony in matters tied to national security and democratic transfer of power. If that conduct is normalized, the guardrails designed after Watergate weaken. Institutional decay accelerates quietly through precedent, and precedent is unforgiving. If a jury hears this tape and convicts, it will mark an inflection point in American history. A former president found guilty not on circumstantial interpretation, but on his own recorded words. If a jury acquits, the reasoning will matter just as much. Either outcome will recalibrate the boundaries of executive accountability. There is no neutral ground left. The recording does not merely allege misconduct. It compresses allegations into audio reality. It forces a confrontation between narrative and evidence. It challenges the claim that investigations are purely partisan when the voice on the tape belongs to the accused. History pivots on moments like this, when documentation replaces rumor, when secrecy unravels under scrutiny, when power meets statute. If you believe constitutional governance depends on evidence, not allegiance, then follow this case closely. The details will not just determine one man's fate. They will signal whether the rule of law can withstand proximity to power. Stay vigilant. The next filing may tighten the frame even further.